Good morning, everybody, and welcome back to our Mason Hayes and Curran series of webinars for schools. It seems like ages ago that we were talking about all of the challenges facing school principals around reopening your schools, and I have to say it's just fantastic to see all the schools open and all the children, students going off to school every morning. That said, we all appreciate in our team the pressures and the challenges that are in front of school principals at the moment. It's a very stressful time, and everybody kind of wishes you the best in terms of keeping your schools open and keeping everybody safe. Before I start, just a quick thank you to NAPD for their support with today's webinar. Can I introduce my colleagues on our team today? My partners, Liam Reardon and Paul Rochford, and my colleagues, Catherine Kelly and David Ruddy. Fiona Shield would normally be on this. Our colleagues, many of you will know her, but unfortunately she's in the WRC today. We're going to focus today on an area which is seeing a rise in queries coming in our door. An area around parents, partners, custody, guardianship, family law issues. And this is an area which we feel schools need support and guidance on. David.
Thank you, Ian, and good morning, everyone. Ian alluded to the huge increase in volume of inquiries in relation to disputes on that. And we can see that this emanates from the statistics we've got from the Central Statistic Office over the last number of years. And as we can see, over 400,000 people now actually live in lone family units. So because of the diversity of our family units, this has been reflected in schools. Schools are a microcosm of society. And this presents you with additional problems and indeed challenges, particularly if there is a conflict or family law proceedings. And Ian, I'm going to ask you just to give us an outline of the type of issues that land on the desks of the education team on a regular basis.
Thanks, David. Well, I've put up some of the issues that come in our door at the moment, and that we're going to drill down into in a couple of minutes. I think before we start, I would like to kind of just talk about two fundamental principles that are in the title of today's webinar: guardianship and custody. Guardianship, from a legal perspective, is a very wide issue and encompasses all the rights and entitlements and indeed duties that parents have for their children. Now, obviously, in the normal course of events, all other things being equal, those rights include day-to-day care, which is really what custody is about. Custody, we often describe as, who puts the beans on the toast, who signs the homework journal if there is one, those day-to-day care. Guardianship is a much wider issue. It includes custody. It's a much wider issue. It includes all sorts of wider issues such as what school a child is going to go to, whether they're going to receive religious instruction, whether they're going to make in a national school their first communion, in secondary school, are they going to do transition year? It encompasses parent-teacher meetings, wider issues than simply day-to-day care. So they're the kind of issues we're going to be looking at, the main issues we're going to be looking at today, and we'll get into the nuts and bolts of those in a second. David.
Thank you for that outline, Ian. And I'm now going to call on Paul. Good morning, Paul. And the questions that have been flowing in, the different rights of different sets of parents and that. So guardianship that Ian alluded to, why is this such an important thing to establish at the outset? So over to you, Paul.
Good morning, David. Thank you, and good morning to everybody. As Ian was outlining there are two distinct concepts between guardianship and custody. And I suppose historically, both would have been contained in the same household and in the same person much more in Ireland than they are perhaps today. But the issue of guardianship is the identifying the person or persons who has that legal authority, the legal responsibility of making certain decisions in relation to the child, in this case, as they pertain to education. So it's governed primarily initially by the Guardianship of Infants Act 1964. Now that has been fairly significantly amended by the 2015 Act, which we'll come to in a minute. But in terms of understanding this, I think what's important for schools to understand is that it's important that they identify who the guardian or guardians are, so that they can ensure that they're getting appropriate authority in relation to the various aspects of the child's education and their life in the school that needs to be done. So, certain people will have automatic guardianship, and this will be fairly easily understood. So the natural birth mother will always be a guardian in almost 100% of cases. Married couples of different sex who have a child, they are automatically guardians in that context. Similarly, same-sex couples who marry and are joint adopters are automatic guardians. Also then, civil partners or cohabiting couples who become joint adopters of a child are automatic guardians. Then there can be circumstances where people can acquire a guardianship, and this is also set out under the legislation. So for example, where the natural parents of the child who are not married when the child is born subsequently marry, then the natural father becomes a guardian by virtue of that act, and that's provided for in the legislation. And then there are a whole number of categories of people who can be appointed guardians by the court. And significant number of these are set out in the 2015 Act. So I think if we move on to the next slide, we will see that the court can appoint various people. So civil partners, cohabiting or step parents, there are various time limits set out in the legislation, both for the period of cohabitation, but also for the period of care of the child. So typically it's 3 years cohabiting, but within that 3 years, they must have been providing parental care to the child for a period of 2 years. Also, and this is becoming, I think, a little bit more common, and certainly can arise quite frequently, is where you may have grandparents acting in loco parentis, as the term goes, but providing day-to-day care for a child. And where they've been doing that for more than 12 months, they can also apply to the court to be appointed as guardians. And then husbands or civil partners who are not the biological father of the child can become joint guardians with the mother if it's in the child's best interest to do so, and that's within the decision of the court. And if certain declarations are made, one of which is obviously that the biological mother would agree to that. So in short, I think the thing to remember is that it's an important point to establish when the child is enrolled in the school, and if you're aware of changes in the family circumstances at those times as well. And it's quite complicated. So I think it would be important, if you have any doubts, you're not sure, or there are challenges raised or issues raised by one parent or another, that you would seek advice on that where need be, because I think getting it wrong is something that you don't want to stray into, and it's easy enough with a bit of advice to get it right.
Paul, you've distilled a lot of information there arising from those two acts. Now, I have two particular questions that I might put to you. The first one is in relation to vaccination. What happens if both guardians cannot agree on a vaccination being offered by the HSE? What advice would you give to them, or give to one of them?
Well, and I think we'll probably return to this theme throughout the webinar on various aspects of differences between guardians or between parents. It's not advisable for a school to get involved in that type of dispute. Obviously, if they are the guardians, then it is their responsibility to make that decision for the child. It's a fairly contentious issue, particularly at the moment, and likely will be within the next 12 months. So I think, it's for the school to say to them, look, we provide the facility for children to get vaccinated. You have to give your permission or consent for that to happen. If you disagree, then you need to go and sort that out amongst yourselves, and then give us a direction as to what the wishes of the child's guardians are. And, you know, that may end up being a joint letter. It may end up being, they may end up going to court, and there may be a court order after that. But that is the remit of the guardians, and the school are best to take a pace back and just say, look, when you have sorted that out, give us appropriate direction and we will follow it.
And thanks, Paul. Another question, just in relation to the whole area of communication. Given the complexity of this, whom should the school be communicating with?
So, you know, I think in general, in relation to important matters concerning the child's education or the child's life in the school. So, for example, if there are disciplinary matters, you know, parent-teacher meetings, end-of-year reports, all of that, it would be normal that would be sent to both guardians if they are perhaps living in separate households. You know, I think the day-to-day kind of very simple things, for example, you know, the examples that I've heard of, like, you know, that there are notices about an outbreak of head lice in the school. You know, I wouldn't think that in most cases that would be necessary to share with the non-custodial guardian, if I can put it like that. So, you know, the guardian the child is normally living with during the week when they're going to school would be the most appropriate person to know about that information. You know, so it can depend on the circumstances, but I think, you know, small, perhaps inconsequential communications like that, I don't think you need to overly concern yourself. But certainly anything significant or anything notable in terms of the child's education, you need to communicate that with all of the guardians.
Thanks for that clarification, Paul. Good morning, Catherine. I'm going to bring you in on this.
Morning.
Just in relation to the whole issue, and again, lots of questions on this, disputed enrollments, father not consenting to the enrollment, or maybe the mother taking the child out of the school and transferring the child to another school, and that. You've dealt with a lot of issues like that, and you've ended up before adjudication officers and indeed in the courts. So what are you saying to boards of management? What have you taken from these proceedings and that?
Well, this comes up always at the start of the school year in relation to enrollments of children and separated parents, and one parent saying they didn't consent to the child being enrolled. And what we normally do is we say to the parent that, you know, the school is not getting involved in family law disputes. The child was enrolled in good faith. If the parent has a court order stating those children can't be enrolled in the school, please produce it and we'll comply with the court order. Sometimes a parent will take a claim stating they were discriminated against, an equal status claim. And the case law on that usually comes down in favour of the school. We had one case where it didn't come down in favour of the school, and that's under appeal now to the circuit court, and hopefully that will be overturned on appeal because it goes very much against the case law.
So Catherine, you're saying that the schools do enroll in good faith. And also we have the issue of the Admissions Act. And of course, it's very difficult, isn't it, for a school to refuse admission unless it's oversubscribed or that.
Well, if you have a place in the school and you refuse admission, then you're going to have a Section 29 appeal, and you will probably lose that Section 29 appeal. You know, if you state, well, you know, you weren't allowed to enroll the child. If there's no court order in place saying that you can't enroll the child, then you need to enroll the child. You know, you'll probably lose the Section 29 appeal if you don't.
You don't. Thanks for that. And Liam, I know that you've been involved in many different cases too. Do you want to make a comment, an overall comment or that?
Thank you, David. Yeah. Just to reinforce what Trina's been saying there, that the case she's talking about is very much against the run of play. I've had several of these cases over the years. I'd one particular parent, a separated father, who took multiple claims against a particular school, all essentially claiming that he was being discriminated against by the school on the basis of his being the father, and he lost all of them. Just really to reinforce the point Catherine was making. That's really it, David.
And the last thing I would say is we did advise recently in relation to a school, and the father keeps saying that he does have an order stating that the children weren't supposed to have been moved, and we have asked over and over again for that order and we haven't received it. So we're going on the basis that there is no order at the moment until we can have a copy of it and we can check it.
Okay, thanks for that, Catherine. And Liam, just in relation to the whole question of custody and access, that causes huge problems in schools. And again, you deal with a lot of this. So what's your take on it?
We do, David, yeah. And to state the obvious, the issues arise because the parents can't agree on custody and access. And again, to state the obvious, this is a matter for the parents and it's not a matter for the school. So ultimately, if the parents can't agree, it's open to one or other or both of them to go to the court, and the court will impose a decision by way of a court order. So we advise schools to stay out of this as much as possible. Now, sometimes it's simply you get dragged into it by necessity, if you like. And a typical type of situation that arises is where we'd say typically a mother who has custody, who is a legal guardian, says that the other parent is not to collect the child. And as far as possible, you have to stay out of that. But one parent will be a guardian and the other parent may or may not be the guardian. Like say typically it'll be the father. If he is a guardian, he has the same rights as the mother in relation to collecting the child and so on, other than if there is a court order that says that's not to be the case. But even then, even if there is a court order, it's not a matter for the school to enforce that order. And if there is a breach of the order, that's a matter for the parties to take to court rather than for the school trying to resolve the matter. And even where there is a court order in relation to access of a particular parent, that does not deprive that parent of his or her guardianship rights if they are already legal guardians. So as Paul was saying earlier, you'd still would have to notify them of major events going on in the school and so on.
David, I just saw, sorry, Liam, I just saw a question pop up there from one of the participants. How do you establish if somebody is a legal guardian if there's a doubt about it? And I just wanted to, the line that we take on the is put the ball in the court of the person who's alleging that, where it's one of these grey areas, where they're alleging that they're entitled to guardianship rights. You know, the ball is in the court of the person who is saying, I am a guardian. And you're perfectly entitled to say, fine, explain why and show me the evidence, you know. Sorry, I didn't want to.
Yeah, no, I agree. And in the case of the, where you're dealing with the mother, I think you're entitled to take it at face value. The mother is going to automatically be the guardian. The reality is, if it's the father or a parent who's not the mother, claiming to have guardianship rights, well, then they can produce evidence of that to show that they are the guardian. Yeah, I agree.
Yeah, on that, I've only seen it once where there was an order from the court stating that the mother wasn't to be involved in anything to do with the education of the children, but that's very rare.
Just one final sort of caveat is that it's not really for the school to sort of carry out some sort of investigatory role. I mean, ultimately, if it's a mess, put it back to them and say, you go and tell us who has rights, and if you can't agree yourselves, show us a court order or whatever. But so it's not. I've seen situations where a school gets, solicitors' letters on behalf of the parents, as if the school has the power to make a decision in relation to one or other of the parents. And I always advise keeping out of that, and if necessary, clarifying the school's position by way of a letter to the parents.
Thanks for that. I think that was a very interesting piece there. And the takeaway is you put the onus back on the parent alleging that they have such rights or whatever. Thank you. We're now going to just have a quick look at the Domestic Violence Act of 2018 and at the different types of orders there, because a lot of your questions referred to these orders. And if I may, I'll put a question to Catherine there. One of these questions, which sort of summarizes maybe a lot of the others, is if a protection order is in place for a family home, can the father come to the school and collect the children? So,
well, again, you're going to have a look at the order itself, and we have advised before in relation to a specific type of order. Sometimes it only relates to the home, so therefore there's nothing preventing the father from coming to the school. So then it's up to the mother to go back, or the father to go back and to get an amended order if that's what they want. We get it a lot at the time of Christmas concerts, where there may be a protection order in place, and the father, for instance, wants to come to see the children at the Christmas concert. I have to have a look at the order to see if it relates to the school, and if it doesn't, he is entitled to come and hopefully behave himself while he's there.
So have sight of the order is really the key point.
Yes, that is the key point, yes.
Thanks for that, Catherine. We're now going to look at the whole area of access to records. And since particularly GDPR and that, schools have been inundated, and so has our office in relation to data access requests. So Ian and Paul, I'm going to ask you to make some comments on this particular issue.
Thanks, David. Well, just I suppose a couple of general comments on what we call subject access requests, data access requests. The first thing is, you know, a parent may make a data access request in relation to data or records held by the school in relation to their child, or in certain cases, they may make an access request in relation to data held by the school in relation to the parent, particularly where there's been a lengthy exchanges in relation to some particular issue. So the first thing to do is look carefully at what the access request says. The second thing is just the body is job one, collect the data, hard copy, soft copy, whatever, collect the data. Make sure if you're giving access to records in relation to a student that you're not accidentally giving access to records related to a third party. And for example, we had one there a couple of months ago in relation to a very complex bullying complaint, one group involving several different students. You know, it's very important that you do not give names or details of other students in response to a data access request, because that would be a data breach. So you have to get into the painful process of redactions, okay? And that's something that needs to be done with care. Other than that, I mean, you know, a parent is, particularly as regards a young child, Paul's going to deal with maybe older teenage children in a moment, but a young child, a parent appears to be entitled, it's not absolutely black and white, but appears to be entitled to make a data access request in relation to a child, because they're effectively making a data access request in the shoes of the child, because the child may be too young to exercise that right themselves. But when you get into the later years, school years, the thing can get a little bit more nuanced, and we regularly have issues around access requests by one parent in relation to a student. And sometimes, of course, in dispute situations, you have the other parent asking you not to hand out the relevant details to the perhaps estranged parent or whatever. And then there's, of course, the rights and entitlements of the actual student himself or herself. And Paul might like to say a few words in relation to that, because that is something that's coming up repeatedly, particularly with second level students. Paul, do you want to chip in there?
Certainly, Ian. Yeah. So, I mean, the thing about it is, as you said, you know, there is a certain lack of clarity in relation to the data rights of children under the current legislation here. Now, the Data Protection Commission has been, for 2 years now, has been engaging in a consultation process in order to come out with a definitive protocol. But what can happen is you can run into objections either from as you say, the teenage student, or in the case of younger students at primary level, perhaps the other parent raises an objection. And I think it's, it's important to understand, even though the age of consent is set here at 16, the actual regulation, the GDPR itself, allowed a range of between 13 and 16, and a lot of other European countries set it at 13. So I don't think, we should look at it as a hard and fast kind of rule. I think, the suitably mature student at 13, 14 may have a view as well. So one of the tools you can use, or the other alternative routes you can go in relation to this, is that aside from a data access request, there is a general provision under Section 9G of the Education Act 1998, which provides that a school should ensure that the parents of a student are provided with or have access to records kept by the school relating to the progress of that student in his or her education. And that can be very helpful and very useful where there are objections raised. You can say, fine, acknowledge your objection, and look, that's a matter essentially for the Data Protection Commission to sort out if there's a complaint. But we have another statutory obligation under the Education Act to provide certain information, and we're providing it on that basis. And the other thing about that particular section is that the definition of parent under the 1998 Act is slightly wider than the concepts of guardian that we've been talking about already in this webinar. So, for example, include foster parents, which we'll come to later on. So there's a little bit more room or latitude there. The only final point I would make on that, just to echo what Ian said about providing responses to data access requests, equally, if you're providing information or records or data under this section of the Education Act, you have to be equally aware of the rights of other parties in providing those records, and they would also need to be suitably redacted so that you're not acting in some breach of those other third parties' data rights in relation to providing that information.
And David, it's worth just saying as well, just as a practical example of what Paul has just said, every year we get a bundle of data access queries from schools relating to, for example, junior cert results. And the guidance that we give, it may well be that an estranged, for example, an estranged father wants to know how his son or daughter has done in the junior cert. And it may well be that the mother doesn't want the father to have the data. Now, this is something I'll come to in a minute. We always say, schools try not to get involved in the taking of sides in these situations. But the data commissioner, their view is, like all other things being equal, go and ask the student. Ask the student, does he or she consent to giving his or her results to dad? And we've had situations, Catherine and I have several situations in the last couple of years where, the school has gone to the student who may be in transition year or something, and the student says either, yeah, give him the results. That's fine, give him the results. Or, no, he's not to have the results. I don't agree with that. And then the school, we've had to write back to parents or help schools to write back to parents and say, sorry, your son or daughter is not agreeable to getting the stuff, getting the results. And you've had a couple of cases. You had one case, Catherine, I think, on that.
I did. Well, it was in relation to, the case we had was in relation to leaving cert results, and it was she was estranged from the father, and he was asking the school, please send me her leaving cert results. I'm entitled to them as her guardian. And she had stated absolutely not. He was not to get her leaving cert results. So he took a claim to state that the school was discriminating against him on the basis that he was a separated father. And the adjudication officer was very clear that that was not discrimination, that she was entitled to refuse to allow him access to her leaving cert results. But we have had an issue also in relation to the junior cert results, and also that came down in our favour.
So the takeaway from all of this really is consent is king, and be very mindful, particularly at post-primary level, of the rights of students in all of this. So thanks for that. I think that was very enlightening. We're now going to move on to the vexed issue of partners, not parents, playing a quasi-parenting role, and many are very involved in the rearing and supporting of families. So Liam, can I ask you just to make a few comments on that?
Yes, can a parent who's not, can a partner who's not a parent attend a parent-teacher meeting? This crops up from time to time, and the answer really is yes, with the consent of the parent who is a guardian. I would be reluctant to agree to allow them to attend something like a parent-teacher meeting or a disciplinary meeting on their own in the absence of the legal guardian, other than in very exceptional circumstances where the legal guardian was indisposed due to illness or being out of the country or whatever. So the key thing here is the consent of the guardian. Can a partner who's not a parent access the personal data? On the face of it, the answer to that is no. But if the parent who's the legal guardian accesses the data and decides to share it with them, that's a matter for them rather than a matter for the school. Obviously, the partner who is not a parent could access personal data with the consent of the guardian, but I think with the consent of the child and or the guardian, but that's a matter for them to organize rather than for the school. So really it's consent is the key thing, the consent of the guardian, consent of the student. And
again, we're putting the onus back on the parent.
Absolutely,
yeah. Carrying the can all the time.
Yeah, the onus is on the parents, both the parents as guardian, the parent or the partner who's the parent, to tell you what the arrangements are.
Thanks for that, Liam. And now we move on to the role of non-custodial parents. Now, these parents are guardians, but don't have custody. Maybe they have access or that. So I'm going to ask Catherine and Liam maybe to make a few comments on that.
Well, again, we'd start off with saying that, this is something that the school can't get involved in. If a non-custodial parent turns up at the school wishing to take the student with them, you should allow them to have the student, unless there is an issue in relation to child protection, or if you have concerns in relation to them getting collected by that parent. We have had instances where parents have turned up and they have been aggressive at the school, and obviously we wouldn't allow that child to be taken by that parent, and we would deal with the Gardaí in relation to that, and we would also put a call into the custodial parent to make them aware of it. So it really depends on the circumstances.
David, I had a situation there a couple of months ago where a school rang in an emergency situation because a person arrived up at the school drunk to pick up a child, and we had to deal with that in kind of a health and safety issue, and ultimately we persuaded the parent to leave after a bit of difficulty, but that was going to be essentially a health and safety duty of care issue, because the Gardaí issue, and we actually advised the school to raid the Gardaí. But these were emergency situations; these wouldn't be common situations.
Yeah, and I mean, we would have to write to the parents afterwards to ask them to sort it out, so that it doesn't come up again. And sometimes, if a parent turns up all the time and is behaving like that, then unfortunately, sometimes we have to bar them from turning up to the school, because it's not good for the other children in the school as well.
And it could give rise to a TUSLA report.
And that's
yeah.
Absolutely.
And just to add there, David, I've had cases where the non-custodial a father simply turns up, walks into the school, into the classroom, and takes his children out of the school, and there's very little you can do, or situations like that, other than to notify the custodial parent that it's happened. You can't ask principals to physically stop somebody who just walks straight in and takes their child out. You can call the Gardaí if there are child protection issues, and then call the custodial parent. But it happens.
Yeah, thanks for sharing all those cases with us, because it is very challenging and stressful for schools, and it can happen out of the blue, as it were. I'm now going to move back to the role of foster parents. Paul, you alluded to it, and very interestingly, you made the point that foster parents were referenced in the Education Act. We were looking at access to information on that. So in relation to the role of the foster parents, what would you like to say?
Yeah, I just think it's important to understand that foster parents do not have the status of guardians, where the child is placed with them for fostering by the Child and Family Agency. The Child and Family Agency maintains the direction in relation to the primary care of that child through the foster parents. So it's a slightly different situation. Now, that being said, particularly in long-term fostering situations, there is a provision under the 1991 Child Care Act for foster parents to make an application to the court to have not guardianship, but certain guardianship-like rights assigned to them by the court. And there are various qualifications that need to be put in place in terms of the consent of the agency, and all of that has to be acquired. But if that order is put in place by the court, then what it says in the legislation is that it will be as if the foster parent were the child's parent. So they will have the ability to give direction and instruction to the school in relation to the child's education.
Hello, Paul.
Can you hear me?
Yes.
Okay.
Yep.
They give direction in relation to the child's education as if they were the parent. And then the other point which you alluded to there is going back to our point about the Education Act, is that on a day-to-day basis, in terms of communicating about the child and the child's education, it may be somewhat simpler in that there is that provision that the foster parent is included in the definition of parent for the purpose of that section of the Act, so that those communications and that information can be given to the foster parent, which makes life a little bit simpler for the school. So, but again, if you have foster parents who say we have applied and we've gotten this order and we have these enhanced rights, as with all of the things we've been talking about today, I think it's important again to emphasize, fine, will you bring me in a copy of that court order, please, so that we can establish that that's the case, and we'll keep it on the file. So, as a former president of the United States said, trust but verify. Get the order into your hand so that you can understand exactly what has been ordered by the court, what's allowed and what's not allowed.
Paul, I was going to say the court order trumps everything, but I better not start into that. But you get my point. Thanks.
Ouch.
In relation to the rights of students over 18, many students doing their Leaving Cert or approaching it will reach the age of 18 years of age, and that brings rights that they achieve their age of majority. They can have a right to vote and own property. And sometimes we come across situations where students will approach the school and request that the school no longer communicates with the parents and just communicates solely with the student. And in cases like that, what we do we would advise the school to write to the parents and inform them that that is the request of the student. Now, invariably, we find that there are discussions at home between the parents and the student, and often the student will come back to the school with a change of heart or change of mind. And I leave that to your imagination, how that might happen or what sort of persuasion is involved. But in an instance where there is a change of heart or mind, well, then you have to deal with the student directly, and the parents don't have access to parent-teacher meetings, or indeed in relation to issues such as breaches of codes of behaviour and that. So that's something just to bear in mind. Another issue that comes up frequently is the changing of a student's surname. So Liam, would you like to make a comment on that?
Yeah, thanks, David. I've had cases where this has been an issue. I had one particularly contentious case where what happened was the parents enrolled the child when they were all living together, and so the school enrolled the child as per the name on his birth certificate. So far, so good. Then the parents separated. The mother had custody of the child and wanted the child to be known only by her surname. And for several years, that wasn't a particular problem. Then the father reappeared, got wind of this, and began demanding that the child be known the name on his birth certificate. And the compromise that we've reached, what I advised the school was that there's a regulation of the Department of Education and Skills somewhere that the name on the birth certificate is the name that goes on the register. That's what returned to the department. So what we said to the father was, well, that's the name on the register. And then whatever name is in use becomes the name that's in use on a sort of as per usage. Because if you think of it in terms of, it's very common for women on marriage to change their name. And that's simply conventional. There's nothing legal about that, but it's recognized and it's accepted. Now, there are various ways in which you can change your name through deed polls and all sorts of things like that. I say to schools, don't get involved in that. That's not your role. If the parents want to produce, deed polls to you or whatever, that's fine. But the birth certificate is, the birth certificate, and that's what goes on the register. And, the rest over time will take care of itself. That's my sort of view on it.
Thanks for that, Liam. That's good, sensible advice. And again, it puts the onus on parents in relation to these matters. Finally, one of the issues that have come up in a lot of our questions too are family law proceedings and dragging teachers and school principals into these proceedings. So Ian, you're going to talk about this.
Yeah, thanks, David. I suppose it's just a general comment first, and some of you who have spoken to me or to one of the other team members in the last year or two will be familiar with this kind of advice, and that is that, family law litigation can be contentious, to put it mildly, and even bitter. And it's really important, as far as possible, that the school and the principal or whatever remains in the kind of neutral space and is not taking or be seen to taking sides between the parties in the litigation. That's just a general view. You're educators. You're not required to take positions in relation, regardless of your own personal, if you like, sympathies. You're not required or expected to take. So just be careful about that. Now, I've put up there a number of, if you like, particular issues that are coming in our door at the moment. Court orders, just two things, I would say, as we've repeated earlier on in this webinar. If somebody's referring to a court order, get a copy of it. Get a copy of the order. It will usually be clear enough in what it's saying, but if it's something that you really feel that you're not familiar with or don't understand, you can take advice. And that's just, I would say that more generally in this whole area, that you're educators, you're not lawyers. So if you really are floundering in regards to some of these issues, which are complex, take advice. That's what advice is for. Requests for reports. Now, sometimes schools are receiving requests in relation to family law litigation for a report from the school, allegedly for the court. And this is a request from often solicitors on behalf of one or other of the parties, one of the parents, for example. And I'm kind of reluctant on behalf of schools to start getting into that because, first of all, you're not necessarily obliged to give a report to one of those parents. You shouldn't feel compelled to do so. In very rare circumstances, a court will actually request a report. And that's obviously something that you might need to take more seriously and would try to comply with. But requests from either one or other party to litigation, I often say, look, we send out end of year or end of term school reports, they're there, and you know the relevant information is contained in that. Subpoenas can be very troublesome and worrying for schools and for principals. So the first thing to say that if you get a subpoena, technically a subpoena is a subpoena from the court and not from one of the parties, even though it may have been sought by one of the parties. So it's not something you can just ignore. Don't put it in the bin and just forget about it. The other thing to say about a subpoena is that, you know, obviously it's open to you to go along and answer the subpoena and give evidence. And if you're one of these principals who really always wants to be a lawyer and you watch court dramas on television with huge enthusiasm, well, good luck to you and off you go. If you're one of these, it's the majority of principals who don't actually, have enthusiasm for spending an afternoon in the witness box being examined and cross-examined, there are a couple of things that I want to say to you. The first is there is no obligation on you as a school principal or indeed a class teacher to have conversations with the lawyer who has sought and served the subpoena in advance of going into the witness box. And I say this because one of the standard pieces of advice that we all got when we were in law school was, you know, never put a witness into the witness box unless you know what they're going to say. And if you don't have a discussion or give an interview or whatever it is with the solicitor for whoever party is seeking to bring you to court, if you don't give them an interview before the court date, it's very unlikely that you're going to be called as a witness. The second thing is, in many cases, we have, if you like, advised a principal to, or else made a call on behalf of a principal to the solicitor who's seeking to call them to as a witness, to arrange that the principal or class teacher can be on standby on the court day. We obviously you have to give a mobile number, and it does mean that you're not kind of hanging around court all day waiting for the case to come up. Obviously you have to, and if you're going to be on standby, you have to leave your mobile phone on, and if you get a call, the deal is you have to come to court. But it very often happens that you don't get a call at all, either because they decided they're not going to call you, or there's a settlement in the matter in between the proceedings or whatever. So they're just kind of some of the strategies that we kind of use to support and advise schools when you are in receipt of some sort of request to get involved in family law proceedings. David.
Ian, I think people will find that insight really valuable, and it will alleviate some of the stress when they're approached by solicitors in relation to family law proceedings and indeed by parents. So thank you very much for that. As we wrap up, we just have a few practical tips here. And just one final question here. Do both parents have to sign an enrollment form if they're guardians? And if they don't, does it invalidate the form in any way? So I draw that. Liam, would you?
Sorry, you go, Liam.
Sorry, David, our view is that it's sufficient to have one parent, one legal guardian signing up to the application. You don't need both. One is sufficient.
Okay, well, thanks for that. And on that note, I'd like to thank my colleagues, Ian, Catherine, Liam, and Paul, and of course we refer to also Fiona, who cannot be with us, for sharing this bank of knowledge today. I think it will be really well received by school leaders, and I think it'll give them great reassurance. It'll give you great reassurance. And I would say above all, if there's one takeaway, do not allow yourself to be pressurized in situations where judgment calls have to be made. Take your time and take advice if necessary. Our team is at the ready to help you if and so whenever you deem it fitting. Ian is going to mail you a link to the webinar if you want to have a look at some particular parts of it again. And of course, we want to wish you continued success with the education of children, and we hope that you will get some respite in the weeks ahead when it comes to the midterm break. So thank you very much and stay safe.
Thank you.